Welcome to SCOTUScast, Racial Gerrymander Edition. Thank you for tuning in. On March 21, 2016, the Supreme Court heard oral argument in Wittman v. Personhuballah. In 2012, the Virginia State Legislature adopted a redistricting plan that altered the composition of the Third Congressional District by increasing the percentage of African American voters in the district. In 2013, plaintiffs, who reside in the 3rd District, sued state election officials, arguing that the district was racially gerrymandered in violation of the Equal Protection Clause of the 14th Amendment. A 3-judge district court agreed and held the districting plan to be unconstitutional, but the U.S. Supreme Court vacated that judgment and remanded the case for reconsideration in light of its intervening decision in Alabama Legislative Black Caucus v. Alabama. On remand, the district court held that the redistricting plan failed strict scrutiny and ordered the Virginia General Assembly to devise a remedial plan. When the Assembly did not do so, the court devised its own remedial plan and ordered election officials to implement it. On further appeal, there are 4 questions now before the Supreme Court. 1. Whether the court below erred in failing to make the required finding that race rather than politics predominated in District 3, where there is no dispute that politics explains the enacted plan. 2. Whether the court below erred in relieving plaintiffs of their burden to show an alternative plan that achieves the General Assembly's political goals, is comparably consistent with traditional districting principles, and brings about greater racial balance than the enacted plan. 3. Whether, regardless of any other error, the finding of a Shaw violation by the court below was based on clearly erroneous fact-finding. 4. Whether the majority erred in holding that the enacted plan fails strict scrutiny because it increased District 3's black voting age population percentage above the benchmark percentage, when the undisputed evidence establishes that the increase better complies with neutral principles than would reducing the percentage, and no racial bloc voting analysis would support a reduction capable of realistically securing Section 5 preclearance. To discuss the case, we have Derek Muller, who is Associate Professor of Law at Pepperdine University School of Law. As always, the Federalist Society takes no position on particular legal or public policy issues. All expressions of opinion are those of the speaker. And now, Professor Muller.
The Supreme Court is considering a long-standing battle over the boundaries of Virginia's 3rd Congressional District. A 3-judge court had found that the district was drawn with improper racial intent. The Supreme Court has the opportunity to scrutinize whether the legislature had an improper racial motivation, or when it drew these districts, it was designed to protect incumbents and primarily for other permissible reasons. But at the same time, the court is also facing a fairly significant question of standing, or the ability to appeal the decision rendered in this case. A 3-judge district court panel found that when the state of Virginia drew the 3rd Congressional District after the most recent census in 2010, it included too many African American voters in that district, which constituted an unconstitutional racial gerrymander. That is, Virginia used race as the predominant factor in drawing its districts. It included too many African Americans in that one particular district. The racial gerrymandering cases largely began in the 1990s when the Supreme Court heard a series of cases, starting with one called Shaw versus Reno, about districts drawn with racial intent, where the shape was so bizarre that it appears it could have only been drawn on the basis of race. At the same time, the court also issued some decisions explaining that legislators might have other motives as well. In Bush versus Vera, the Supreme Court recognized that incumbent protection is a permissible decision in legislatures deciding how to draw their districts. And in Easley versus Cromartie, it recognized that partisanship might be another factor that prevents race from being considered the predominant factor in drawing these districts. So in the end, the question is whether any consideration other than race may have predominated the decision-making process when Virginia drew these particular districts. The 3-judge district court cited a recent Supreme Court case concerning Alabama, and that the Alabama legislature had apparently insisted on maintaining the same percentage of black voters in the existing districts without any evidence that that same percentage of black voters was required to preserve the ability of those voters to elect a candidate of their choice. This really ties into the Voting Rights Act and Section 5 of the Voting Rights Act in particular. The 3-judge panel found that one remark by a redistricting proponent suggested that the district should include a black voting age population of at least 55%. And by having that kind of automatic benchmark, the court was worried made this a racial gerrymander. similar to what had happened in Alabama. The district at the time, the Third Congressional District, had a black voting age population of about 53%, and it might have had a much lower African American population in order to preserve the ability of African American voters to elect the preferred candidate of their choice. You see, when Virginia was submitting its maps, it had to get preclearance from the Department of Justice because the Voting Rights Act, and specifically Section 5, required that any changes to election laws had to go through the Department of Justice for preclearance to avoid retrogression. That is, are African American voters worse off with the new law than they were under the old law? And Virginia, wanting to make sure that it was complying with Section 5 of the Voting Rights Act, was trying to come up with some standard to make sure that there were enough African Americans in a particular district, but not too many to constitute this kind of racial gerrymander or intentional discrimination the Constitution and the court's case law suggested is impermissible. Of course, part of this inquiry is even further academic, as the Supreme Court in Shelby County v. Holder struck down Section 5 of the Voting Rights Act, so it would no longer apply to new maps being drawn in Virginia, and simply is a question of the motivation that was affecting the legislature at this particular point in time when it was drawing these maps. So the district court, finding that this remark about the 55% benchmark for the Third Congressional District was troublesome, decided to redraw its own map based upon some expert testimony. It adjusted the lines from the Third Congressional District with a neighboring district. It shifted a significant number of African Americans into that adjacent district, but the shift had a significant political consequence as well. The adjacent district had been a somewhat safe Republican district in the sense that there was an incumbent who was a Republican who was in a district that had slightly favored Republicans in the past, and now was residing in a district that had a significant influx of Democratic voters, which meant that it would likely mean that a Democrat would be elected in that particular district. So much so that it prompted the incumbent Republican legislature in the adjacent district to switch and move into a different district to run in that other district in order to increase his chances of seeking re-election. So it has a clear partisan impact on the House of Representatives, whether or not Virginia's original plan stays in place or whether the new plan drawn by the three-judge panel stays in place. So the Supreme Court was navigating a number of these issues, all sort of interrelated with one another, about race and party and incumbent protection, about finding the motivations of the legislature, about this Section 5 of the Voting Rights Act put up against the racial gerrymandering charge. And many of the questions were sort of mixed ones of law and fact. So some members of the court were wondering about this test, about examining the intent of the legislature. And then they were also asking whether or not the record supported such a finding of fact that the legislature did have this predominant motive of racial intent rather than some other purpose like protecting incumbents or protecting a particular political party. Chief Justice Roberts asked many of the advocates a hypothetical about where 10% of the legislature said it had a racial intent, 10% said that they had a partisan intent, and the remaining 80% of the legislature was silent as to their intent. How are we supposed to discern, he asked, the intent of the legislature when we concede that there are many mixed motives that legislatures might have? So one response would be to say, well, we look at the impact that it has, or we look at some of the stray remarks that are made, and those remarks are sufficient to rise to this level to give inference to a finding that there was racial motivation, and unless it's clearly erroneous, it won't be overturned on appeal. At the same time, the other response is, well, when we look at the clear partisan advantages that were designed within the map or the incumbent protection that was designed in the original map, maybe we should be granting more deference to what was happening in the legislature. Complicating the analysis was that the new maps drawn by the three-judge district panel, relying upon expert testimony, didn't take much care to try to help protect incumbents or the partisan decisions that had been made by the legislature originally. So some justices, including Justice Breyer, worried aloud that we might be handing too much power over to courts to cure a racial gerrymander by ignoring other things the legislature itself might want. But further complicating the analysis was a matter of standing. It's an issue that the court asked the parties to address before it would even agree to hear this case. See, Virginia election officials chose not to appeal the lower court's decision, that lower court finding that there had been a racial gerrymander. As a result, current and former members of Congress from Virginia who had intervened in the case in order to protect their own existing districts had appealed the case to the Supreme Court. So the Supreme Court asked them to address why or whether they have standing to appeal. In the end, only two districts' lines had moved, the Third Congressional District and the adjacent district, where the court had moved the voters between those two districts as a result of the new maps. And the court repeatedly asked whether any of the interveners had standing to appeal, particularly as to the one candidate whose lines were redrawn and then filed to run in a different district, essentially conceding the race in this particular district. There was a question about whether or not the interveners had an injury in fact. That is, the injury seemed to be the right to run in a particular district with some kind of incumbency advantage. And Justice Kagan worried about whether or not this was an injury in fact, but more specifically whether this was an injury in fact to a legally cognizable interest. Is incumbent protection a legally cognizable right? It might prove too much, in her view, to grant all legislators some generic right to have an easier time getting reelected as incumbents. Otherwise, wouldn't their injury just be a fairly generalized grievance, as if they were ordinary voters? After all, candidates can still run for office. They're simply running for office in a district that has a slightly different composition of voters. But Justice Alito worried about the discretion given to the state here when it declined to appeal the case. If the state was filled with racists who didn't want to appeal a finding because they were racially motivated and didn't want the Supreme Court to hear a decision, would a court be unable to hear the case in one such as this? Confusing matters was the fact that this occurred on appeal. Usually the questions of standing happen addressing this question of the injury in fact to a legally cognizable interest. And we worry about whether or not plaintiffs have that sufficient injury in fact to a legally cognizable interest. But here the defendants are sort of put in a defensive posture and on appeal arguing that they have an injury to their legally protected interest, and whether or not they need to assert the same kinds of things on appeal defending their rights as plaintiffs would have to allege in their complaint when they file the case at the outset. Finally, in hinting at a prediction in the case, the parties had, before the Supreme Court heard this case, asked for an emergency stay to stop the new district from taking effect, to stop the lower court from redrawing the lines and to let the old maps take effect for the 2016 election. But the Supreme Court chose not to issue an injunction or stay the decision. It let the new maps drawn by the three-judge panel control the primary election and presumably control the November 2016 election. That suggests a lower likelihood that the Supreme Court is going to find that the map was permissibly drawn, and instead perhaps increases the likelihood that it's going to agree that the district court, with the district court's finding that this was an unconstitutional racial gerrymander. As when the court is deciding whether or not to grant an injunction or grant a stay in a case such as this, one of the factors it considers is the likelihood of success. So the lower the likelihood of success, the less likely the court is going to grant a stay in such a case as this. So perhaps it is a hint that the court will find that this case is an unconstitutional racial gerrymander. Or it might simply find that the interveners lacked standing to appeal the decision to the Supreme Court, and the lower court's finding is going to stay. Finally, it also complicates the picture trying to predict what's going to happen given the passing of Justice Scalia. It may very well be that this is a kind of decision that ends up a 4-4 summary affirmance simply because it's an equally divided court that can't reach a decision. Justice Scalia was often the fifth vote and decisive vote in cases such as these with racial gerrymandering disputes, and it might be the case that we see an equally divided court and some of the effects of the passing of Justice Scalia and an 8-judge Supreme Court.
Thank you for listening to this episode of SCOTUScast. For more episodes of SCOTUScast, as well as audio and video of past Federalist Society events, please visit our website at www.federalistsociety.org/multimedia.